I am discussing the article about status of undertrials in India. As per NCRB, National Crime Report Bureau, over the last 10 years, the number of undertrials in jails has risen constantly and peaked in 2021. In 2020, about 76% of all prison inmates in the country were undertrials, of which about 68% were either illiterate or school dropouts. Delhi and Jammu and Kashmir, J&K, were found to have the highest ratio of undertrials in jails at 91%, followed by Bihar and Punjab at 85%, and Odisha at 83%. About 27% of all undertrials were found to be illiterate, and 41% had dropped out before Class X. I will try to highlight the concern. My first concern is resourceless prisoners. There are many poor and resourceless undertrials who continue to be disproportionately arrested, routinely remanded to judicial custody in prisons. They are unable to seek and secure bail either because of lack of economic resources or because of fear of the social stigma outside. Secondly, there are ample incidents of violence and abuses in jail. Prisons are often dangerous places for those they hold. Group violence is also endemic and riots are common. Physical mishandling and extrajudicial torture by jail officials are actually seen in India. Health problems of prisoners is a prime concern. Most of the prisons face problems of overcrowding and shortage of adequate space to lodge prisoners in safe and healthy conditions. People are cramped in with each other in unhealthy conditions, infectious and communicable diseases spread easily. Example, spread of tuberculosis, TB. Constitutional protection for undertrials. The subject comes under state list. Prisons persons detained therein is a state subject under entry 4 of list 2 of the 7th schedule to the Constitution of India. Administration and management of prisons is the responsibility of respective state governments. However, the Ministry of Home Affairs provides regular guidance and advice to states and UTs on various issues concerning prisons and prison inmates. Recommendations of Committee for Reforms in Prison are many. The Supreme Court appointed Justice Amitav Roy, retired. Committee, which has given the following recommendations to reform prisons. For overcrowding. Speedy trial. Speedy trial remains one of the best ways to remedy the unwarranted phenomenon of overcrowding. Lawyer-to-prisoner ratio. There should be at least one lawyer for every 30 prisoners, which is not the case at present. Special courts, special fast-track courts should be set up to deal exclusively with petty offences which have been pending for more than 5 years. Further, accused persons who are charged with petty offences and those granted bail, but who are unable to arrange surety should be released on a personal recognizance, PR, bond. For prisoners. Accommodative transition. Every new prisoner should be allowed a free phone call a day to his family members to see him through his first week in jail. Legal aid. Providing effective legal aid to prisoners and taking steps to provide vocational skills and education to prisoners. Use of ICT. Use of video conferencing for trial.